A man tried to set a house on fire, but in court, he promised to change his life.
Court is calling 2021 CR 10875, State of Texas versus Jose Castañon. Can I have parties announced for the record for the state? Defense.
George Schaefer is here for defendant, Your Honor.
And are you Mr. Castañon?
Yes,
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. There are no applications.
No application.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
you do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on a lesser included attempted arson, which is a second degree felony.
Any objection?
No, Your Honor, we'd ask the court to approve the state's request to amend.
All right. And Mr. Castañon, did you review the document entitled Court Admonishments and Defendant's Waivers and
Yes, ma'am.
Affidavit of Admonitions?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of attempted arson of a habitation or place of assembly? That's a second degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine.
Understood.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Understood.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Understood.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, understood.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does now, Your Honor, although I'll point out for the record that in March of 2022, he was determined to be incompetent to proceed. He's gone through restoration services and has again now regained his competence to proceed. I find him so competent today as well.
All right. And do you believe he was sane at the time of the offense?
I do, Your Honor.
Mr. Castañon, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of attempted arson of a habitation or an assembly. Punishment is to be assessed at 2 years in the prison, and there are no applications. Did you understand that to be the plea?
Understood.
Defense?
It is, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Understood. Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Understood.
Counsel, are there any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Exhibit number one, all this.
No objections, Your Honor.
All right, states, you may continue to confer. Did you review the document entitled Wavering Consent to Stipulation of Testimony and Stipulations with your attorney? Did you
Yes.
understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Understood. Yeah, she's reading the report to make sure there's enough evidence there to support your plea. Okay.
And, all right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. And counsel, you don't believe there is an issue of sanity?
No, Your Honor.
All right. Well, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes,
Anything you wish to say on behalf of your client?
Judge, other than the fact that he's been in custody for a long time and has withdrawn from his use of alcohol and other substances, I think the defendant is prepared to accept the sentence of the court at the present time.
All right. Mr. Castagnon,
Yes, Your Honor.
when you're released, what are your plans?
My plans are to get my life together, first report to Center for Health, and get my identity and things going, and get me a place to live, which is a good environment, would be for a facility where would be groups for mental health, place would be in a good environment, would be no drugs, alcohol involved, that would be not permitted.
All right. Do you have any family support?
Yes, I do, my brothers and my sisters.
Okay. And have you been in contact with them since you've been in custody?
Contact quite a bit with my brother.
Okay. All right. The court is going to follow your agreement, sentence you to 2 years in the prison. I'm going to ask for mental health treatment while he's at the prison. However, I have no jurisdiction over that. Yes.
He has 907 days credit.
All right. So I understand that, but here's the thing. I am sentencing you to the 2 years. I can even say judgment satisfied in it, but they're maybe will still transfer you to the prison to process you. Has he ever been to prison before?
State jail.
All right. So you may not be in their system. And if you're not in their system, it's going to take longer for them to process you. All right. So 2 years, TDC. I'm going to order mental health. When you get there, they'll probably tell you where you can go to get mental health treatment. I'll give you credit for any time served. I'll show that the judgment is satisfied. State, do you agree that the judgment is satisfied?
Yes, sir.
All right, I'll show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So usually what ends up happening, they usually will transport you to the prison. I don't know what the overcrowding situation is, so they may release you from the Bexar County Jail. They may not. So if they're transferring you to prison, just know the judgment will be in the system and they'll be able to see it. If there's some issue with any of his credit that he's received, your counsel can always come back to court. When you're released, if you cannot find where you need to go for mental health treatment, you can always come back to the court. If I'm here, I will direct you to the location so you can get treatment and make sure you stay on your medications. You understand?
Yes.
And if you are on your medications and they have bad side effects, you need to let your doctors know, because maybe they can give you something else. Don't just disregard them, okay?
I was on my in Bakersfield, but here at the jail, they don't have it. So, but when I get back to, what's called Center for Health, they'll put me back on my injection.
Okay. All right. Good luck to you. All right.
Thank you.
You're welcome. Thank you, counsel.
Okay.
The courtroom session begins in a calm and procedural manner as the defendant stands before the judge to resolve a serious charge involving attempted arson. From the outset, everything appears controlled and routine. The attorneys confirm that discovery has been reviewed, the defendant acknowledges understanding the indictment, and the legal process moves forward step by step. There is no visible tension, just another case moving through the system. The charge has been reduced to a lesser-included offense, and the defendant agrees to enter a plea of no contest. The judge carefully explains the consequences, including a possible prison sentence of up to 20 years. The defendant confirms his understanding and waives his right to a jury trial. On the surface, it seems like a straightforward resolution. However, a critical detail emerges. The defense attorney informs the court that the defendant had previously been declared incompetent to stand trial and had undergone restoration services. Now he is considered competent again. This revelation shifts the tone of the courtroom. Suddenly, this is no longer just a legal case. It becomes a story about mental health, accountability, and second chances. The judge proceeds cautiously, ensuring that the defendant fully understands the situation. After reviewing the evidence, the court finds sufficient grounds to declare him guilty. The case then moves into sentencing, where the judge gives the defendant an opportunity to speak. What follows is a moment of vulnerability. The defendant explains that he wants to rebuild his life, seek mental health treatment, and stay in a stable, drug-free environment. He speaks about reconnecting with his family and finding a place where he can receive proper care. For the first time, the courtroom sees not just a defendant, but a person trying to recover from his past. The judge listens carefully, but remains firm. While acknowledging the defendant's intentions, the court emphasizes the seriousness of the crime. Attempted arson is not a minor offense. It carries significant risk and consequences. Justice must still be served. In the end, the judge decides to follow the plea agreement and sentences the defendant to 2 years in prison. However, the decision comes with an important addition. The judge orders that the defendant receive mental health treatment while incarcerated, recognizing that rehabilitation is just as important as punishment. The judge also explains the practical realities of the sentence, including processing time and the possibility of transfer to prison. The defendant is given credit for time already served, and the court confirms that the judgment is satisfied under the agreement. As the hearing concludes, the judge offers guidance for the future, emphasizing the importance of continuing treatment and staying on medication. It is a rare moment where the courtroom blends discipline with compassion. The case ends not with anger or chaos, but with a quiet, powerful reminder. Justice is not always about punishment alone. It is also about the chance to change. Not every criminal is truly bad. Some people are just broken. If you enjoy real courtroom cases like this, subscribe to the channel and like the video, because every case here tells a story.